Okay, well, good morning, everyone. Welcome to Senate Judiciary Committee. We will now call the committee to order. And the first order of business is final action on bills previously heard. However, I'm going to wait until we have a few more of our committee here before we proceed. We have a quorum. But actually, let's go ahead and start again working House Bill 2078, otherwise known as the Speedy Trial Bill. When last we were together in our committee, we had amended the date of suspension of the right to statutory speedy trial. And we were considering some other things. If the reviser, Mr. Thompson, could kind of bring us up to speed on House Bill 2078 and where we were with the amendment.
Thank you, Madam Chair. This is Jason Thompson with the Reviser of Statutes Office. You're correct. When you last had this bill up for action, you amended it to change the date, the sunset date, to May 1st of 2023. And a further amendment was discussed, and you agreed to hold for further action.
Thank you, Mr. Reviser. Committee, any questions for Mr. Thompson at this point? When last we met, we were discussing having a reporting requirement from the judicial branch, and there were a few technicalities that we needed to put into the proposed amendment regarding fiscal year reporting and how often the report. It was commented in committee that even without a reporting requirement, the committee could set a hearing and have the judicial branch make the report. So while we are working this House bill, if we amend it further, we've amended the House bill once, we changed the date. If we amend it further and insert a reporting requirement, as we send it back to the House, that's one more additional change for the concur or non-concur vote and something to discuss in conference committee. So is there any discussion from the committee about that process? Senator Corson.
So thank you, Madam Chair. So I had prepared an amendment that addresses the very good points raised by Senator Baumgartner and others, and I've worked with the Office of Judicial Administration on the wording, and so I think that I have an amendment that I think meets the issues that were raised at our previous meeting, and so I guess I could offer that if the committee felt like it was beneficial. I guess just to give sort of some context, my main reason for preparing the amendment was that it seemed like there were consistent concerns from committee members throughout our work on this about having enough information or having good information on how to assess if we were in a position down the road where we were being asked to consider a further extension. We wanted to make sure that we had the information in front of us that would be most pertinent to helping us make that decision as a committee. And so that was the reason that I prepared that amendment, would be to be assured that we would get timely reports with the information that committee members had expressed an interest in knowing about. That said, obviously, as the chair has pointed out, we could ask for that information separately from putting it in the statute. We could, if the chair wished, we could have further hearings on it to try to obtain that information. So I sort of leave it to the committee's input as to whether this amendment would be helpful in furthering us. Thank you, Madam Chair.
Thank you, Senator. So committee, you've heard conceptually what the amendment would do. I think it's important that today we pass this bill out of committee in whatever form we're prepared to do that in. And Senator Wilburn, I think, has a comment.
Thank you, Madam Chair. I think Senator Corson articulated very well that this committee felt strongly that there needs to be some sort of a reporting requirement sometime. Having said that, I refer to the chair's recommendation that we address that in a separate bill so that we can move this one along in a speedy manner. And so that's the way I lean right now. Thank you.
Senator Pyle. Thank you, Senator.
Madam Chair, I know I expressed some sentiments last week, and we still don't have, I mean, it's not that complicated. You got to be able to give us a list of all 2019, all 2020 criminal cases that are currently backlogged and have that now so that we can look at that in a year from now, and we ought to be able to see what's still on the list and what's not on the list and what's been completed. I think it's important for the judiciary to show their work, and I think that I would like to see Senator Corson's amendment before we move the bill out, because we did look at that last week and we were told, you know, we had this amendment with all these points on it, and we kind of wanted to divide it to just make sure there's a report. I think that ought to be in this bill. I don't think having a reporting requirement causes a problem with a concur or non-concur. The House can certainly understand that we need to know that they're going to report on that. This does not address my concerns of getting current information right now to date so that we know. It's easy for me to look at a spreadsheet and say, hey, these reports are where we're at today. These cases are where we're at today. This is the backlog. And then a year from now, hey, we've worked through quite a few, or we haven't worked through hardly any. We can't do that if we don't have the baseline. So while I understand the report and I'm for the report, I think we need something today, and I think that that could be provided for us as a committee without a requirement for today. But I think that the reporting requirement for next year so that we can review it, I think is important. And I don't know that, you know, we're going to have time for another bill. I see how many bills you have lined up to work in the next week or so. So I would like to see his amendment if he has it, please.
Thank you, Senator. Senator Corson, do you want to offer your amendment?
Sure, I would offer it, and Iris is able to distribute it, and Mr. Thompson, with your permission, Madam Chair, is able to project it.
Yes, Mr. Revisor, if you could put the, it's reporting updated. There we go. And Senator, if you want to explain your amendment or have the revisor do so.
Mr. Thompson, do you want to go ahead and explain it?
Mr. Thompson?
Sure. Thank you, Madam Chair. Jason Thompson with the revisor again. Thank you, Senator Corson. So the title here explains pretty well what's going on, requiring the Office of Judicial Administration to prepare and submit a report to the Legislature in 2022 and 2023. And the changes are then on page 3. They'd be inserted here at line 33 as subsection L. The Office of Judicial Administration would have to prepare and submit a report to this committee and the House Committee on Judiciary on or before January 10th of 2022 and January 9th of 2023. I would just note those are the first day of the session in each of those years as required by the Constitution, the second Monday in January. And then the report would contain the following information delineated by judicial district. First, the number of pending cases for on those dates, January 1, 2022 and January 1, 2023. The number of cases, criminal cases resolved during the fiscal year 2021 and 2022, and the method of disposition in each case. Third, the number of jury trials conducted in criminal cases. And fourth, the number of new criminal cases filed in those fiscal years. So in 2022, it would contain the data for 2021, and in 2023, it would contain the data for 2022. And I think that's covers it.
Thank you, Mr. Thompson. Committee, any questions for the revisor? I have a question. You had said that the reporting requirement would be that the report be made to the Senate and the House committees on judiciary on or before January 10th, 2022 and January 9th, 2023. Those are the first days of session, and it's often we don't have the ability to put an agenda out to include that on the agenda. And so I'm just concerned about that first day of session. But we'll have discussion on the amendment. All right, we're not very talkative this morning, but okay. Is there any discussion on the amendment? I guess we have to have a motion regarding the amendment and a second, and then we'll discuss the motion.
Thank you, Madam Chair. I would move my amendment.
We have a second from Senator Pyle. Discussion on the motion. Just again, regarding my comment, I'm concerned about those particular dates, January 10th and January 9th. But yes, Senator Thompson.
That's probably a very good point, Madam Chair, and I don't know if we can do one on the fly or a conceptual amendment, just to say that we received that report within the first week of session, just so we have, some leeway in that date. And I just open that for discussion.
Right. Is that a substitute motion?
It would be if, yes.
Is there a second for the substitute motion? Yes, Senator Bowers. And Mr. Revisor, Mr. Thompson, with that, are you okay with the conceptual amendment changing on the fourth line of the balloon from January 10th, 2022 to, I guess the conceptual amendment would be change it to January 17th and the following date, instead of January 9th, 2023, January 16th, 2023. Is that the conceptual amendment? And Mr. Revisor, is that acceptable to you in that form?
Thank you, Madam Chair. This is Jason Thompson again with the revisor. I was just doing a quick search to see if we reference the first week of session, the first 2 weeks of session, and yes, there are a couple of reports that are due in that time frame. So we could say during the first week of the regular session, we could say during the first 2 weeks of the regular session, or we could specify a date. All of those are sufficient.
Thank you, Mr. Thompson. Senator Thompson, it's your substitute amendment?
I think the hard date's probably a good idea rather than give it too much leeway. Maybe within by the like you said, the 17th, 2022, and that'd be January 16th of 2023. That gives the Judiciary Committee chair particularly a little bit of leeway on which day we have to have that report, but it would at least set a date certain.
And we have a second for that motion from Senator Bowers. Committee, any discussion on the substitute motion and amendment? Seeing none, then you all have heard the motion. All those in favor, aye. All those opposed, nay. The motion carries. We are back on the bill. Are there any other amendments or discussion? Seeing none, then do we have a motion? Senator Gossage.
Madam Chair, I move that we that we concur. Is that correct?
That we pass favorably out of committee House Bill 2078 as amended.
That we pass favorably House Bill 2078 as amended.
Thank you. Mr. Revisor, is that an appropriate motion?
Yes, Madam Chair. I just wanted to clarify that you did adopt the full amendment with the date change. And if you did so, then you're having a motion now to move the bill as amended.
You're cutting out a little bit. If you could speak more directly into the microphone.
Sure. Thank you, Madam Chair. This is Jason Thompson again. I just wanted to clarify that the previous motion to amend was the full amendment, but with the date changes at the beginning. And if so, you've now amended the bill and a motion to pass out as amended is appropriate. You just need a second.
Thank you. Do we have a second? Senator Corson. So committee, it's with those two amendments, the one changing the date of suspending the statute until May 1st, 2023, and then the reporting amendment that we just adopted and passed today. So committee, you all have heard the motion. All those in favor say aye. Aye. All those opposed, nay. The motion passes. Thank you, committee. We will now turn to hearing today. Hearing on House Bill 2071. If we could have a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. Trying to switch screens here. All right, House Bill 2071 increases the criminal penalties for stalking a minor. KSA 215427, current law is the crime of stalking, and that is amended to add a new provision for intentionally engaging in a course of conduct targeted at a specific child under the age of 14 that would cause a reasonable person in the circumstances of the targeted child or a reasonable person in the circumstances of an immediate family member of such child to fear for the child's safety. Violation of this new provision would be a severity level 7 person felony on a first conviction and a severity level 4 person felony on a second or subsequent conviction. And I will stand for questions.
Thank you, Mr. Thompson. Committee, any questions for the reviser? Yes, Senator Corson.
Thank you, Madam Chair. I just had a question about the age of 14. Is there any is that age set in statute in other related context, or is there any reason why it was, not all children under 18, which is generally what we consider a minor? I'm just sort of wondering about how the age of 14 was selected and if there are other similar statutes that maybe also use 14, because again, I just had thought maybe you'd want it to protect 15-year-olds and 16-year-olds and 17-year-olds as well, but thank you.
Thank you. Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again. Senator Corson is correct. It is a policy choice to choose that age. So I'll defer to the conferees to explain why they chose 14. But I will also acknowledge that there are several statutes, particularly sex offenses, where the severity level goes up significantly if the victim is 14 or younger. The Jessica's Law cases, as we call them. So it's not an uncommon thing in our criminal statutes, but it is a policy choice.
Thank you, Mr. Thompson. For those who are following along online, would you inform us of the penalties for a severity level 7 person felony?
You bet. Thank you, Madam Chair. Jason Thompson again. We pull up my sentencing grids. So, and I believe I can actually share this as well. So let me try to do that real quick. I have the Sentencing Commission's PDF here. Well, that's still the bill brief. See if I can share it here. I apologize for the technical difficulties here. All right, you should be able to see that. So severity level 7, you can see here is on the top, the low end, no misdemeanor, no record. We're in the range of 11 to 13 months, and it is presumptive probation. And then at the top end, where you have 3+ person felonies, you're in 30 to 34 months, and it is presumptive imprisonment. And then if you go to a level 4 for a second or a subsequent offense, you're looking at 38 to 43 months on the low end, presumptive imprisonment, and 154 to 172 months on the high end, also presumptive imprisonment.
Thank you, Mr. Thompson. And then it would be a severity level 7 person felony on a second or subsequent conviction. And could you tell us what that sentencing grid is for severity level 4 person felony.
Right, thank you, Madam Chair. So, yeah, I was trying to clarify that first offense, level 7, second, subsequent, level 4. That's the level here where it's 38 to 43 and 154 to 172.
Okay, thank you. Committee, further questions for the reviser? Senator Thompson.
Yes, I noticed in section 1, it points out recklessly engaging in the course of conduct targeted at a specific person. Would that not already cover someone under the age of 14?
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again. Yes, of course, stalking covers a person of any age. I think you'll hear from the testimony that there might be some particular issues with children and meeting the elements of that crime as it currently stands. And I will obviously defer to your conferees to explain to you why they're having trouble prosecuting this particular conduct and why they want you to change the policy so that they can prosecute it more effectively or more efficiently.
Thank you, Madam Chair.
Thank you. Committee, any other questions for the reviser? Seeing none, then we will invite our first proponent conferee to the podium, Ms. Kristen Antonucci of #NotYourDaughter. Welcome. Please introduce yourself and welcome to committee. Yeah, that's fine. And make sure you turn on the microphone with the button. Yeah, you can take your mask off if you prefer. Thank you.
Hello, my name is Kristen Antonucci. And I'm honored to speak in support of Bill 2071. I look forward to sharing our personal story and need behind this bill to increase criminal penalties for stalking a minor. I've been a resident of Kansas the majority of my life, a business owner, a wife, and a mom to 3 kids. March 10th, 2020 was just like any other Tuesday. I went to pick my children up from their elementary school and was prepared to shuttle them around to school activities. My children hopped in the car just like they normally do when I turned around to notice that my oldest daughter had a look of despair on her face. I immediately asked her what was the matter, and she indicated something bad had happened at school that day. She explained that her friends and classmates had approached her on the playground at the end of the day recess. She said she didn't want to talk about the situation in front of her little brother or sister. It was too inappropriate. She had tears bubbling in her eyes and tears running down her face. I could hardly bear waiting to hear what had upset her so much. Once we arrived at our destination, she told me that her classmates, who were 9 and 10 years old, had let my daughter know at recess that they believed their 4th grade teacher had been taking inappropriate photos of my daughter. They had seen him for months, sneaking his phone or iPad out. He'd look around and then video or photograph her from behind while she was not looking. The sweet friends also indicated they had told their parents. One friend had been so smart at just 9 years old that she'd even tried to switch desks with my daughter the week before to try to remove her from harm's way. I was in complete shock and disbelief. The next morning, the teacher was confronted about what the girls had been witnessing. My daughter's 4th grade teacher admitted to law enforcement to having an obsession and an infatuation with my 10-year-old daughter. He admitted that he did in fact use his classroom as a place to photograph and video her for his own gratification. We were all shocked, stunned, mad, and upset. He had taken hundreds upon hundreds of videos and photos of her on the playground, walking down the hall, eating lunch, tying her shoe. Upon interrogation, he further confessed additional alarming details, admitted that she had fit his type. She was not the first minor student he had stalked and photographed, but ultimately his behavior had escalated the furthest with her. A third of all stalkers have more than one victim. How he described her disturbed law enforcement. The things he said about her in almost a boastful way were highly alarming. In my mind, he would have been arrested right there on the spot, especially because he was admitting all these things to police. We were in utter shock to know that a grown man in his 50s with children of his own would walk free that day after admitting that he viewed a child as attractive, that he would violate her trust and use his position of authority to take photos and videos of her backside and rewatch them when he went home. And he had been searching for information on her and our family. He had researched enough to know what he could get away with and didn't believe that because he hadn't escalated it to a physical point and she was clothed in pictures that he wouldn't be charged with anything. My anger quickly turned to fear. The man who had been stalking my child for the last 8 months and who had done enough research on her and our family was now walking free. He knew where we lived, where her extracurricular activities were located, and obviously where she went to school. This man's obsession for her had bubbled up so much that he had gotten sloppy enough for children just age 9 to catch on to his behavior. Here's a man that was willing to risk it all, his job, his wife, his status within his church, and a relationship with his own children for his obsession with my child. What else was this man capable of? What other lengths would he go to? A forensic sweep of his personal electronics came in. Day after day, we were briefed by the child victim detective who would let us know what they had found on his electronics. More photos of our child, additional searches for her online, looking up information on our family, looking up directions to her dance studio, which was just 1 mile away from his home, and looking up how to come to extracurricular activities, competitions, and directions to those events. My innocent 10-year-old daughter had to undergo police questioning. That day was really hard. She jumped on the trampoline and rode her bike before the detective arrived. My husband and I watched her, wondering how a grown man could view this child as attractive. She was just a child. I was in awe of her as she navigated the tough questions being asked while my husband and I sat in horror with tears flowing behind our sunglasses. The detective let her know that they were working hard to bring her justice and described how laws in Kansas don't always protect children like they should. She boldly declared that day that she wanted to help us work on changing laws to help protect other children. I began to sleep on the hallway between all my kids' bedrooms at night to make sure they were safe, to make sure that he didn't try to get to our sweet girl. The fear was consuming at times. An announcement that COVID-19 was shutting down schools that week was welcomed. I didn't want to let any of my kids out of arm's length, and the shutdown was the best case scenario for our family. For 3 months, we lived in fear, hoping and waiting for him to be arrested. We were ready to breathe a sigh of relief. On June 12, 2020, the call we had been waiting for finally came. We were notified that my daughter's 4th grade teacher would be arrested that day. I always took any calls from detectives or the DA's office in my car to ensure our children were not fully aware of the details. I had to protect their innocence the best I could. As I walked back into the house after hearing he would be arrested, my daughter asked why I looked so relieved. She could see it on my face. I did let her know the teacher would be arrested that day. She gave me the biggest hug and said, "Thanks, Mom." We received another call from the assistant DA letting us know that what he would be charged with was just a misdemeanor. Reckless stalking, a crime that carried a maximum sentence of a year, if even that, with a $10,000 bond. The teacher was arrested and taken to the courtroom where he was officially booked and spent just a couple of hours. I don't think he actually even ever went behind bars. The sense of relief quickly dispersed as the fear crept back in. Our elation turned to sadness, then to anger, then to fear. He was booked and almost immediately released, where he is now angered. I feel more scared than I had ever felt. This man knew where he lived. He has nothing stopping him from finding us. We decided it was best to spend the night at a relative's house and more vulnerable than ever. That night, news hit that an Olathe teacher had been arrested for stalking his 10-year-old student hit the airwaves. We are still waiting for the outcome of our case. I had spent 3 months with the full intent of never telling our story, never disclosing our identity. I watched as individuals and classmates who were aware of the story at no fault of their own made assumptions about the case and the story online. Because children were the ones that had reported him, our identity quickly spread. We decided with our daughter's permission to tell our story. Here's the thing. If you want to invoke change, it's impossible to do it in the shadows. We quickly made it our mission to fight with law enforcement and the district attorney's office to change Kansas laws to protect our children. The innocence, emotional, and physical well-being and the lifelong quality of our children should be valued far beyond protecting the bad guys. Our children are not meant to be preyed on by pedophiles that consume their innocence for their own sake gratification. This leads me to why we are here today. We are so grateful for all the bipartisan representatives that have supported our cause. The original stalking bill, Jody's Law, was originated by a courageous family who lost their beautiful 19-year-old daughter to a stalker. He had preyed on her and her family, starting when she was just 15 years old before ultimately taking her life. We hope to take their law and enforce additional punishments for those who stalk minor children, 14 and younger. Stalking is a prerequisite to a more harmful behavior, and an actionable increase in punishment would help to prevent stalkers from engaging in additional behavior. 54% of victims of homicide reported stalking to police before they were murdered. Passing this bill would afford minor children victims the protection they deserve. We wish to give a voice to the often voiceless, which we believe can be accomplished by raising the statute to a felony level written in Bill 2071. At every turn of this process, we were so shocked to learn that our children are not fully protected, whether it be in similar circumstances or assaults. We never thought this would happen to our family or our child. Our family, with the help of law enforcement and the DA's office and legislators, have made it our mission to update all of these archaic laws. I'm hoping this isn't the last time you see me fighting for the rights of our kids. This situation has made our elementary school child have to grow up way too fast, experience a loss of trust and overwhelming fear. No child should ever have to go through a situation like this, and if they do, the predators should be punished accordingly. Detectives indicated that this type of stalking is posturing to do something further and more horrific. We are forever grateful to those brave classmates who courageously stood up for our daughter. There have been many times our daughter comes up and gives us a big hug or tells us thank you for standing up for her. We hope to take that passion and fire and stand up for all kids. We thank you so much for your time and hope that you will too partner with us to help keep Kansas kids safe. We hope that you will agree that punishments need to be heightened to a felony level to deter predators. We need to send a clear message to those that prey on our children that behavior like this has no place in our state. By passing 2071, we can begin the process of updating these statutes to prosecute those that violate our children. Enough. Let's stand up for Kansas kids and say, not our grandchildren, not our daughter, not our sons, hashtag not your daughter. Thank you.
Thank you very much for your testimony, for appearing here in person in front of the committee. We next have hearing from Adeline Antonucci, also with hashtag not your daughter. So please take your time, introduce yourself, and welcome to committee.
Thank you. Hello, my name is Adeline Antonucci, and I want to thank you for considering our bill today. I want to thank my parents, classmates, and those who have supported my story. I know a lot of hard work has gone into creating this law to keep kids safe. Being part of this important process and movement has given me a sense of happiness. Last year, I was a 4th grade student who loved being my class student government representative, being a competitive dancer, hanging out with my friends on the playground, and playing Foursquare at recess. I was shocked to learn from my classmates that our teacher had been acting inappropriately. The feelings I've had this last year are sadness, worry, fear, and confusion. I do not think these are feelings that kids should have to have, especially from an adult, in a place that is supposed to be safe. I feel like no other kid should have to go through a situation like this. When my mom said that she wanted to work to change the laws to protect other kids, it made me feel happy. I would really appreciate your support of this bill. If this bill protects one other kid, then we have won. If it stops one other person from doing bad things to a child, it is worth it. I am so thankful that my parents have been working hard to fight for the victims of stalking in Kansas. I'm forever grateful for those classmates who protected me. Now I want to help to protect other children. Kids need to be safe and feel safe always. Thank you so much for your time and helping us pass this bill.
Thank you very much. Thank you also for appearing in person today and testifying with us today. Committee, you have proponent written testimony in your committee folder from Steve Howe, Johnson County District Attorney. And I will ask, do we have any more proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, committee, are there any questions for our conferees? Senator Baumgardner.
Thank you, Madam Chair. I just want to say thank you to Adeline and to her family. Adeline, I attended the same school that you did, as did 5 of my brothers and sisters. So when your story hit the news, my antennas went up because, by golly, that's not what classroom experience should be like for Mustangs. And I want to thank you so much for having great friends that looked out for you. We do try and pass bills that protect children and protect Kansans, and so thank you for having great parents that worked with our District Attorney, Steve Howe, so that we can make a change that will make Kansas even more safe for kids. So I just want to say thank you.
Thank you, Senator. Other questions or comments from the committee for our proponent conferees? Senator Thompson.
Thank you, Madam Chair. Just referring to the written testimony by Stephen Howe, attorney for Johnson County, suggested perhaps age 16 might be more appropriate. And I think given the varying levels of maturity for different children, I would probably consider proposing an amendment to up that age to 16 and under. That's just a comment.
Thank you, Senator. Committee, other questions or comments for our conferees? And I just got a note that we do have Mr. Steve Howe, Johnson County District Attorney, on WebEx. If any committee member has a question, he has offered to stand for questions if we have a question for him. Senator Thompson.
Yeah, I would ask if he would feel like age 16 would be more appropriate as the threshold rather than 14.
Mr. Howe?
Yes,
If you
Senator,
state your...
the reason why we use the age of
Hold on a
14
second. Could you introduce yourself just for those listening online?
I'm sorry.
Welcome back to committee.
This is Steve Howe, Johnson County District Attorney. I appreciate the opportunity to answer your questions. Senator, the reason why we picked the age of 14, as indicated by Jason Thompson, is that other criminal statutes have used that as a delineation to indicate an age where people are particularly vulnerable. And so the reason why we picked 14 is, if you think about it in these terms, that is typically the age of middle school kids. When you get into 15, 16, and 17, you're talking about high school kids. And so that is the reason why we picked that age. I did put in my written testimony that 16 is the age of consent, and that's another age that the legislature has used throughout the criminal statutes. Part of the concerns with the current statute was it was not clear from the wording of the statute that knowledge was required by the victim. And so we wanted to put some other clarifying language in the statute to make sure that the knowledge requirement was not required. We won that at the district court level, but my concerns were that at the appellate level, there might be a successful challenge to the law. Now it prevents that from being a defense to the crime. And so what we can now do is hold those accountable that are good stalkers, because the way the statute's constructed now, should we actually reward individuals for being good at stalking and not being caught? And we thought that was a ridiculous position to have. So this reasonable person test or language that we have is something that's used throughout our criminal statutes. And we think this protection, as well as distinguishing between 14 and under and those above 14, is the appropriate way to go. So that's a little bit of an explanation.
Thank you, Mr. Howe. And committee, I forgot to have the reviser inform us, since this is a House bill, it has passed out of the House, and the vote in the House was 125-0. So, yes, Senator Pyle, did you have a question?
Yeah, for Mr. Howe. Mr. Howe, would you have a problem with moving this up instead of the statute book to the Kansas Register publication?
Mr.
I'm
Howe?
sorry, I couldn't hear you.
Mr. Howe, would you have a problem with changing the effect date instead of the statute book and move it up to the printing and the publication in the Kansas Register?
I don't
Mr.
have
Howe?
a problem either way.
Okay.
Whatever this committee wants to do, I think what we want to see is that these additional protections be put into place. And I'll leave it to the committee's discretion as to when that would take effect. But whatever you can do would be beneficial to cover this type of conduct.
Thank you. Just, Madam Chair, if the reviser would just make sure that when we work this bill, I think that's something we can do probably conceptually, but if you think we need an amendment to offer, then I would like to do that. Thank you.
Okay, thank you, Senator. Committee, other comments or questions for any of the proponent conferees? I want to also personally thank the Antonucci family for the advocacy you have engaged in what has been sounding like a most difficult and trying time. I myself have 4 kids, 3 of them still in the public schools, 1 having graduated, and including one of them still in middle school. So it's nice to have good friends watching out for each other as well, and parents watching out for kids too. So appreciate all the time you have put into this, and for the representatives on the House side who have been working to bring this bill to us today as well. With that, committee, then, if there are no other questions or comments, we will ask for neutral conferees in the committee meeting room or on WebEx. Seeing and hearing none, we will ask for opponent conferees in the committee meeting room or on WebEx. Seeing and hearing none, then, we will close the hearing on House Bill 2071. Committee, we will then open the hearing on House Bill 2001. If we will have a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson with the reviser of statutes again. Let's see if I can share this. Yep. All right. House Bill 2001, as amended by the House Committee, creates the crime of sexual extortion and requires certain offenders to register under our Kansas Offender Registration Act. The new crime is defined as communicating a threat to injure the property or reputation of another person, a threat to commit violence against a person, or a threat to distribute an image, video, or other recording of a person of a sexual nature or in a state of nudity, either with the intent to coerce the person to engage in sexual contact or produce a sexual image, which is a severity level 7 person felony, or that causes the person to engage in sexual contact or produce a sexual image, which is a severity level 4 person felony. The bill also provides that a person who commits this new crime, where one party is less than 18 years of age, is required to register as a sex offender for 15 years under our Offender Registration Act. The House Committee on Judiciary added an amendment that exempts juvenile offenders from that registration requirement. So it would only be adult offenders that would be required to register for committing the crime of sexual extortion, and only when one of the parties is less than 18 years of age. And I will stand for questions.
Thank you, Mr. Thompson. Committee, questions for the reviser? Seeing none, then, we will hear from our first proponent conferee, Kate Owen, with Legal Momentum, who is appearing on WebEx. Please introduce yourself and welcome to committee.
Morning. Thank you so much for your time today. Chairwoman Warren, Vice Chairman Wilborn, and members of the committee. My name is Kate Owen, and I'm an attorney with the law firm Orrick, Harrington & Sutcliffe. And I'm here on behalf of our client, Legal Momentum. We are pro bono counsel for Legal Momentum, and we have worked together along with lawmakers across the country for several years to ensure that sexual extortion, which is a form of sexual assault, is fully criminalized. We strongly support efforts to criminalize sexual extortion in Kansas, and we thank you for your time in addressing this important legislation. I'll start with just a very quick background. With sexual extortion, instead of demanding money or property, the offender here demands sexual images or in-person sexual acts. Sexual extortion is not a new crime, but it is one that has rapidly proliferated in the last decade as technology and the internet have evolved with social media and smartphones in the hands of nearly every adult and child. Predators have near constant access to torment victims in Kansas and beyond. Will offenders use a variety of threats and tactics? I'll give an example of how we frequently see this crime originate in its modern online form. An offender will obtain private, often sexually explicit images of their victims by various means, such as by hacking into their computers or smartphones, or by pretending to be peers or friends on social media sites. But once the offender gets a hold of an intimate image, they want more. They use a variety of threats to coerce a victim into providing more images or engaging in in-person sexual conduct with them. A common threat is for an offender to say that they will distribute the images to the victim's family, to their friends, to their employer, or all over social media, unless the victim produces and sends them more or engages in sexual activity with them. Victims who are often teens and young women feel as though they have no option but to comply with the perpetrator's demands. And offenders make the demands over and over again for months, even years, tormenting multiple, even dozens or more victims. And the victims are sexually assaulted every time they are forced to take off their clothes and take a sexually explicit picture against their will. Every time they are forced to record a sexually explicit video against their will, or meet in person for sexual acts against their will. Victims of this form of sexual assault suffer harm like that of any other sex crime. We are so passionate about ensuring that this conduct is criminalized because we know it's happening and we know that reports are rising. And like all gender-based violence, we believe it's actually far underreported and that it's only gotten worse during the pandemic as everyone is home and more reliant on technology than ever before. Also alarming, sexual extortion has been used by human traffickers as a way to coerce and recruit victims into human trafficking. And as we've seen with sexual extortion, we've seen it in the housing context as well. We've heard reports of vulnerable tenants being threatened with eviction unless they take sexually explicit images or engage in sexual acts, and of people with limited housing options being sexually extorted to secure a place to live. As with many states, sexual extortion does not fit squarely within Kansas's existing sexual conduct and blackmail offenses. But with this bill, Kansas has the opportunity to lead on this issue and modernize its laws to fully criminalize sexual extortion conduct. This bill creates a clear new statute that will recognize that it's not only a crime to extort money or property, but that it's a crime to extort sexual images and in-person sexual conduct. On behalf of Legal Momentum, thank you for your time today, and I urge you to support this important legislation. And I'm happy to answer any questions. Thank you again.
Thank you very much. Next, we will hear from proponent conferee Lindsay Ford with the Kansas Coalition Against Sexual and Domestic Violence. Please introduce yourself and welcome to committee.
Good morning. My name is Lindsay Ford. I'm the staff attorney with the Kansas Coalition Against Sexual and Domestic Violence. We represent 25 domestic violence and sexual assault programs across the state of Kansas. I just want to thank you all for your time today in considering this bill. Sexual extortion is a form of blackmail in which one person induces another to have sexual contact or perform sexual acts, or in the case that we're addressing here, to potentially provide sexual content, whether it be in the form of pictures or video. And this is done by the use of threats of violence, by the use of threats of economic injury, or a threat to a person's reputation. The most recognizable version of sexual extortion includes a threat to publish sexual images unless the victim engages in sex acts or continues to provide additional sexual content to the perpetrator. And we all know what the publications of sexually explicit images like this can do to a victim, what the impact it can have on their reputation, their careers, and then their personal psyche for having to undergo such a traumatic violation. The law currently addresses the non-consensual publication of private images, but it does nothing to protect those who are being threatened with the publication of those images. It only intervenes at the point that the damage has already been done. And also, as we know, once these images are out on the internet, there's no way to take, nothing's ever really deleted from the internet. So the harm and the victimization continues for years. I think it's very important to note that the victims of these crimes are often children, young girls, teenagers, who are unaware of maybe some of the avenues of help available to them when they are being threatened. And the fact that there is no clear delineation in the law to protect them doesn't do anything to reinforce the idea that they could potentially seek help from law enforcement or trusted adults. So it's very important that the state act to create laws to discourage this sort of behavior, to punish this behavior when it occurs, and to keep the people of Kansas safe. Thank you. And with that, I'd be happy to stand for any questions.
Thank you. I will then ask for, are there any proponent conferees in the committee meeting room or on WebEx, other than who we've heard from? Seeing and hearing none, then, committee, we will open it up for questions for our proponent conferees. I have a quick follow-up question for our reviser, or possibly Natalie Nelson with research. Do other states have a similar law, or maybe this is for our conferees, or would we be the first? And whoever wants to answer, please identify yourself, and then we'll hear from you.
This is Natalie Nelson with Legislative Research. I am not aware. I haven't done that research yet. I can look into it and get back to the committee. But
thank you. Do either of our conferees have that information?
Yes, Madam Chair, this is Kate Owen with ORIC. I'm happy to answer that question. Since about 2017, there are 15 states that have taken express action to expressly criminalize sexual extortion conduct. It fits in a variety of places in their laws with varying degrees. The majority of them do classify it as a felony. And we have a list that I'm happy to circulate after this hearing that we can provide to you that has links to some of these statutes in it.
Okay, thank you. Committee, other questions? Yes, Senator Haley.
Thank you, Madam Chair. And my question too is for the reviser, or for either one of our revisers, Mr. Thompson or Ms. Nelson. I'm wildly supportive of this underlying bill. And I guess my question is, we have had carve-outs for this activity previously in what's known as the Romeo and Juliet exceptions. So my question is for the reviser, where both parties, both the offender and the victim, are under 18, which would be a carve-out in other statutes for this activity. If I'm reading this correctly from their memo, the final paragraph, the bill also provides that a person who commits a new crime where one party is less than 18 years of age is required to register as a sex offender for 15 years, close quote. If the offender is under 18, 16-year-old, if you will, offender who engages in what ultimately is revenge porn with someone who is also under 18, would then that offender, if convicted under this new law, be required to register for 15 years as a sex offender? Chair.
Sure, I think that's a question for the reviser. Mr. Thompson?
Or Ms. Nelson, either.
Thank you, Madam Chair. Jason Thompson with the Revisor's Office. And yeah, I tried to clarify that a little bit with what the House did in their amendment, but I'll point you to the specific provision to make it a little more clear, hopefully. So in order to commit this this crime and have registration be required, one of the parties has to be less than 18. just going to point you to the page for that particular thing. So on the top of page 8 of the bill as amended, so you are a sex offender under the definition of the Offender Registration Act if you committed sexual extortion as defined in section 1 when one of the parties involved is less than 18. So if both parties are over 18, no registration is required. So that's step 1. If one of the parties is under 18, registration is required, except if you go to page 7, we have an explicit exception for a person adjudicated as a juvenile offender for an act which, if committed by an adult, would be sexual extortion as defined in section 1. So if you, as the offender, are a juvenile, you would not be required to register, even if you as the party are under 18 or the other party is under 18. So hopefully that makes sense.
Let's clear it up.
Thank you, Senator. Thank you, Mr. Thompson. Following up on page 7, the House amendment. So this contemplates that the offender who is a juvenile would be prosecuted as a juvenile offender, but not be required to register on the adult sex offender registry. Do I have that right?
Thank you, Madam Chair. Jason Thompson again with the revisor. So it gets a little complicated. If you're adjudicated as a juvenile offender, you are not required to register, period. There's no special provision for the juvenile registration. That's a different kind of idea that is sometimes used, but it's not applicable here. You're just not required to register at all. If you are tried as an adult, you would not be adjudicated as a juvenile offender. So there's the potential that a 17-year-old, for example, gets moved to adult prosecution and is convicted. They would be required to register because they are not adjudicated as a juvenile offender. So that kind of the separation of the juvenile system and the adult system does come into play there.
Thank you. Committee, other questions for the conferees or the revisor? Seeing none, then I will ask for, are there any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none. Are there any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, I want to bring to the attention, if we haven't already, that House Bill 2001 passed the House 123-0. It looks like some legislation that would help protect Kansans from this kind of criminal activity. So with that then, committee, we will close the hearing on House Bill 2001. We do have some additional committee time. We do have a busy week coming up. You'll notice that on Wednesday, we are having the confirmation hearings on our 2 Court of Appeals appointees. The packets are available if you would like them before then. We currently have some time. We can turn to working the 2 bills that we heard today while they're fresh in our minds if we're not anticipating any amendments. So then we can turn to House Bill 2071. We can work House Bill 2071. That was the Not Your Daughter bill that we heard. And we'll open it up for discussion, or if anyone has an amendment that they would need to bring, we cannot work that today then. Senator Pyle.
Thank you, Madam Chair. I would just like to see it changed from statute book to the Kansas Register, please.
That's right. We did hear that amendment. Is that a conceptual amendment, Mr. Revisor, that we can do, or do we need to work this bill tomorrow?
Madam Chair, Jason Thompson with the revisor again. In the discretion of the chair, of course, it's just the final clause of the bill, a simple strike of statute book and putting in register. So if the committee chairperson is willing to make that conceptually, we can certainly do that.
Thank you, Mr. Revisor. We'll try not to do too many conceptual amendments. I know we were doing one with House Bill 2078. So I would like to make it just as clean as we can. So I'd like to bring that amendment tomorrow, if we could, and have that cleared up. Senator Baumgardner?
Well, thank you, Madam Chair. I was simply going to second that motion because I think the changing of the date at the end is very common. It allows us a shell, if you will, but I guess we'll hold that till
Well, if it's, I'll ask the reviser who I did, that if it's something we can do, again, we like to stay away from conceptual amendments, and the senator did say that, but if it's something that we can do and work today, we're happy to do that if we have the motion and the second from Senator Baumgardner. Mr. Reviser? We're going to go ahead then with the conceptual amendment, if that's okay with how we need to put it in the books.
Thank you, Madam Chair. Jason Thompson again. Yes, if you have a motion and a second and the chairperson is willing to entertain it, I'll tell you specifically, it's on page 3, line 28, strike statute book, insert Kansas Register. That's it.
Thank you. Committee, would you like to close on your motion, Senator Pyle? We have discussion from Senator Haley.
Thank you, Madam Chair. I support the expediency of the implementation as much as everybody. I had kind of hoped with the way the schedule is going that we would look at a consent calendar on this measure, not knowing what the calendar is going to be. That way we're automatically passing the provision, which was unanimous out of the House, and we wouldn't have to worry, hopefully, about any additional schedule problems. But I do support the expediency, and with the change, of course, it puts it in play for the whims of the procedures of the Senate as opposed to consent. Thank you, Madam Chair.
Thank you, Senator Haley. Further discussion on the motion, on the amendment? Seeing none, then you all have heard the amendment. You've heard the motion. All those in favor, aye. All those opposed, nay. The motion passes. So we're back on the bill. Yes, Senator Thompson.
Yeah, the only other potential change I would say is maybe upping the ante and going to under 16. I know the district attorney, Howe, mentioned that 16 is the age of consent, but by saying under the age of 16, you'd provide additional protection for kids who are 15 years old and just an extra year. And I don't know, if that's up for discussion. It's certainly one I would offer if the committee feels like that's necessary.
Thank you, Senator Thompson. I think that we're getting too far afield with conceptual amendments, so if that's an amendment that we want to bring, we ought to stop our work on House Bill 2071 and take it up another day. We did hear from the Johnson County District Attorney that it was appropriate to keep it 14 for kind of appeals purposes, whether that gets into whether you're regarding consent and things like that. So I think the ultimate conclusion of the Johnson County District Attorney was 14 was what was put in the bill, because for those kinds of considerations it was appropriate. But Senator Baumgardner.
Chair, I move we pass out House Bill 2071 as amended.
Is there a second? Senator Pyle. Discussion on the motion. You all have heard the motion then. All those in favor, aye. All those opposed, nay. The motion passes. Committee then, I'll open it up to working House Bill 2001. If there are any anticipated amendments, we can work it another day, but we just heard 2001. We were going to get that list of the 15 other states that criminalize this sort of behavior. If committee wants to wait to get that list, we can work it a different day, or if not, I would entertain a motion. And if there's no motion, then we'll work this House bill another day. Yes, Senator Baumgardner.
Thank you, Madam Chair. I move we pass out House Bill 2001 favorably, and it on the consent agenda, though I understand that this may be something that we want to discuss or debate on the floor. At this point, my motion is that it go on the consent agenda.
Senator Gossage with the second. Committee discussion on the motion. Senator Pyle.
Just a procedural, this bill will go forward unamended. Unless it's amended on the floor, we'll go directly to the governor. If the chair is interested in a conference major, then we probably ought to just change statute book to register, just so it is amended. Just if the committee's purpose is fine going forward, I don't have a problem with it. I'm just a word of some interest there that maybe we should just amend it just a little bit so that.
Thank you, Senator. Just a moment. Thank you, committee. There's been a motion that's been seconded regarding the House Bill 2001, and I understand the purpose of the consent calendar. However, this bill has not been heard and run across the Senate floor before for the body as a whole to determine and debate it. So I'm myself questioning if that's the direction the committee wants to go. Any further discussion on the motion? So, yes, Senator Pyle.
Just, I'm sure you understand this and you know this, but if you put this on the consent calendar, there is no opportunity to amend or to use it for conference. If that's the chair's desire, then fine. I have no problem with that. But if the chair's desire is to put this on the calendar so that it can be amended on the Senate House floor or the Senate floor, we'll just make a substitute motion to pass it out favorably. But my preference is to go ahead and amend the statute to the register publication so that it is amended either way. Then if we put it on the consent calendar, at least it's been amended. We could still do that, Madam Chair. There are a lot of options with the bill. Just I'm not clear.
Thank you, Senator. I'm not clear either at this point where we are on the motions, so we'll have to have the revisor clear that up, but Senator Baumgardner first.
Thank you, Madam Chair. I'm willing to withdraw my motion of the consent and simply say that we move it out, pass it out favorably, though I do understand that there is an issue, and I think it really gets down to, do we want to make sure that we have another shell? And if we do, then I think we need a motion. I'll just withdraw my motion for the consent and wait for the senator from Brown to make the motion to change from the statute book, and I will be happy to second that motion of his.
Thank you, Senator Baumgardner. Senator Pyle? Do we have a second? We do from Senator Baumgardner. Mr. Revisor, so that you're clear where we are on the motion, would you state for the committee the motion before the committee?
Thank you, Madam Chair. I am having a little bit of trouble hearing everyone, so if we could speak a little more directly into the microphones, that might help. But I believe we had a motion to pass the bill and place it on the consent calendar that was moved and seconded, but then withdrawn. Now we have a motion to amend to change the effective date from statute book to Kansas Register, and that has received a second. So you're on a motion to amend, if I'm understanding correctly.
Thank you. You all have heard the motion regarding the amendment. On that motion, all those in favor say aye. All those opposed, nay. The motion carries. We are back on the bill. Just a moment, committee. Okay, committee, then we are back on the bill. Senator Baumgartner.
Thank you, Madam Chair. I move that we pass out House Bill 2001 as amended favorably.
Thank you, Senator. The second, Senator Gossage. Committee, any discussion on the motion? Seeing none, then you all have heard the motion. All those in favor, aye. All those opposed, nay. The motion carries. Committee, that is our agenda for today. Thank you for your hard work and your consideration, and for the time of those following online. Thank you to our conferees who appeared in person and on WebEx. And with that, committee, then we are